Good afternoon, and my name is Morrell, and I'm with Kaplan Morrell, and today we are talking about time, and we're going to be talking about time a lot in the next few weeks. And so many times people have questions, injured workers have questions like, how long will this take? How long will my case last? How long does the doctor have to do this? How long does the insurance company have to do this? How long, what time? And so we thought we would do a number of videos on times in workers' compensation. And so the number one question a lot of times people get is, how long can I report my injury? How long does it take? How many times? How long do I have to report my injury? Is there a time limit? Now, most of you see these kinds of signs in your employment. Yes, we actually employ people here. I'd love to say we import Oompa Loompas to do all of the work, but sadly, that darn Willy Wonka, he cornered the Oompa Loompa market, and so we have to have employees just like many other companies unless you do roofing. Apparently roofers don't think they have employees, but that's a different topic altogether. And so if you work somewhere, you probably see one of these signs, and here's a big one on workers' compensation. And it says here that if you are injured on the job, you have to give written notice of your injury to your employer within 4 working days of your work injury. And so a lot of times we get clients, people who call us who've been injured on the job here in Colorado, and they say, well, I reported my injury, but my employer said it was too late because I hadn't given written notice within 4 days, and so therefore I'm not covered under workers' compensation. And this is a lie at worst, or it's mistaken at best. You should give notice of your injury to your employer, and you should do it in writing, because oftentimes I get clients who say, oh yeah, I told my employer about it, and then the employer starts to say, no, this person never reported a work injury. And that's why I'm always asking my clients, is there a text message, is there an email, something that says, hey, this happened at work? Because if you do it in writing, you are protected, because then the employer can't come back and say, you didn't report the injury. And this is so critical. And believe me, now it's so easy to give somebody a written notice of your injury because you can text them, you can email them, etc. Imagine back in the days before texting and before emails, you actually had to write something out or get on a typewriter and print it out. And that was frankly a little weird and a little daunting and intimidating to do, to give somebody written notice of an injury. And these days, it's just as simple as a little text message. So please, for the love of God, if you've been injured on the job, inform your employer that you've been injured in writing. And don't think that you saying, oh wow, my shoulder hurts, or oh wow, I went to the doctor because my shoulder's really sore and the doctor is saying I need this, that is, even if it's in writing, advising your employer that you were injured on the job in writing. Because what's missing from those text messages is, hey, this injury occurred at work. That's the critical thing. Now, what happens if you don't do it within 4 business days? And I've been representing injured workers in Colorado since 1995, now heading on my 26th year of doing this. And the answer is nothing. If you don't do it in writing within 4 business days, that doesn't necessarily mean that you don't have any rights, that it's too late, that you can't claim any benefits, etc. I don't recommend waiting, because the more time between your injury and you giving notice, such that the employer says, yeah, they told us, the better. Because the more time that passes between the injury occurring and you finally telling the employer in such a way that the employer can't deny that you gave notice of the injury, whether it was verbal or not, it gives the employer an opportunity and their insurance company to say, maybe this didn't happen at work. So the more time that passes, it's hard. Especially if in between your injury and when you finally give notice, something weird happens during that time frame, like you get fired, you quit, a weekend, a big ski trip, a big vacation, etc. Because once those things start happening in between the time of your injury and you giving notice, the insurance company is going to look really hard and see maybe your injury occurred because of that, or maybe you're only claiming you got injured after you were terminated because you're angry. So, bottom line, 4 days, yes, good idea. Yes, you should do it in writing. Yes, you should do it. But if you miss that deadline, or if you report it verbally and your employer says, hey, let me send you to a doctor, and they send you to a doctor and the doctor bill doesn't come to you, you're going to be fine. Again, time and law and work injuries can be really complicated, and if you have suffered an on-the-job injury, please, 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 there is an attorney who can help you here in Colorado. We love what we do, and we would love to help you. We only charge a contingency fee, which means you only pay us if we're successful for you. And with that, thank you for spending part of your day with me.